The Trump administration just announced that they are adding staff to 80 USCIS field offices around the country with a single mission to identify and revoke citizenship for 100 to 200 naturalized citizens per month. This is an exponentially higher number than the total amount of revoked citizenship cases that occurred under the Trump administration 1.0. They're calling it a zero tolerance policy for fraud or misrepresentation. They've identified 10 specific immigrants who have obtained naturalized citizenship that they want to target for the denaturalization process. So we're going to talk about that more in the video here. I'm going to break down exactly what they're targeting, what is the process of denaturalization, and to talk about whether you have anything to worry about. Hi, I'm Jake. I'm the head attorney and founder at Immi Visa Law Group, one of the top immigration law firms in the state of Utah. If you have any immigration questions you would like considered, we have our eligibility form in our About Us section. Just send the link in our profile on YouTube. Feel free to click that and fill that out. All right, let's go ahead and get into it. If you are a naturalized citizen or if you have family members who are naturalized citizens and you're concerned about this possibility, please watch this video. I'm going to break down exactly who is at risk, what are the legal protections available, what is the standard for obtaining denaturalization that the government needs to approve, and a few other considerations for us to talk about. Let's talk about where this all came from. According to reports from both NBC News and the New York Times, the Trump administration has released an internal memo requesting that USCIS field offices identify between 100 and 200 cases for denaturalization per month. So let's compare this to some of the numbers from previous administrations and from President Trump's first term. So between 1990 and 2017, the US averaged somewhere around 11 cases of denaturalization per year. So during President Trump's first term, there were around 100 total denaturalization cases that were referred to DOJ during the entire 4 years of his first term. This number dropped significantly under the Biden administration when it only had around 24 or so denaturalization cases that were referred. Now, the Trump administration wants to refer somewhere between 100 to 200 cases per month, which again is exponentially more than the total amount of denaturalization cases ever since 1990. So yeah, that would be more denaturalization cases in a single year than the US has had in the previous 3 decades combined. Even though as a raw number, only around 2,400 cases of denaturalization is small compared to the total size of the American electorate. This is pretty significant if you think about the scope of how many denaturalization cases this would include. Again, this is essentially unprecedented, the scale that this would be at. So let's talk about how the Trump administration proposes to do this. So right now, they have proposed appointing a single specialist to 80 different field offices across USCIS for United States Citizenship and Immigration Services. And that specialist's sole mission would be to comb through records and identify cases where denaturalization would be an appropriate enforcement tool. This is where those specialists would refer those cases to the Department of Justice, who would then need to pursue those in a court of law to have denaturalization enforced. So yeah, this is a pretty different model than what the Trump administration was doing during President Trump's first term. Back then, there was just a single location out of Pasadena, California, where they ran these sort of denaturalization referrals. But this one would involve a specialist in, again, 80 or so field offices across the country. So this is going to significantly increase the scale at which denaturalization occurs. I think this sort of enforcement aligns perfectly with the Department of Justice memo. Who did that come out by? Yeah, so that came out from Assistant Attorney General Brett Shumate. These field office specialists go right in line with a Department of Justice memo that went out in June of 2025, where the DOJ essentially said that denaturalization would be one of their top 5 enforcement priorities. So all this is just lining up to say this is definitely going to be something to watch out for here in the coming months. I'm actually going to quote a line directly from the DOJ memo from June of 2025. The memo directed the DOJ attorneys to prioritize and maximally pursue denaturalization proceedings in all cases permitted by law and supported by the evidence. A USCIS spokesperson also confirmed that there is a zero tolerance policy for fraud. So where USCIS, the DHS, and DOJ align, you're going to see denaturalization going forward here much more commonly than previously expected. Okay, so now let's talk about who they're actually going after here. So they did release a list of 10 enforcement priorities with denaturalization. Let's talk about each of them. I think a lot of these actually make sense as a matter of policy. I think most Americans would agree. Some of these may be more problematic than others. Let's talk about these. So number one, individuals who pose a threat to national security. These are those who support terrorism, espionage, or the export of USCIS technologies, people who are stealing US IP. I think everybody can agree we do not want these people to be naturalized citizens. Number two, human rights violators. Those who have participated in war crimes, torture, or genocide, those people are going to be targets for denaturalization. No complaints here. Number three, affiliates of transnational crime organizations, think drug cartels. Number four, individuals who concealed felony convictions during the naturalization process. I have never actually seen this in practice. You do have to disclose any felony convictions on your N-400 application for naturalization. And in pretty much every case I have ever seen, even where an applicant has forgotten to include a crime, let's say they just didn't even tell their attorney or didn't show up in their background check, it has come up in USCIS's security search when biometrics are provided. I've never actually seen a case personally where someone was able to conceal a crime that USCIS was not able to identify. Number five, those convicted of human trafficking, certain sex crimes, or violent offenses. Number six, those who have committed financial fraud against the US. So this is going to include Medicaid fraud, Medicare fraud, and PPP loan fraud. I strongly suspect these cases are going to become headline news. I think this is likely to be the broadest category of denaturalization cases that we're going to see going forward. I think this is particularly timely given the DOJ and Department of Homeland Security's investigation of certain states in the US where there are large immigrant populations where fraud or perceived fraud has been ongoing. You could think of the Somali community in Minnesota as one. Number seven, those who have committed fraud against private individuals or entities. Number eight, those who obtain citizenship through fraud, misrepresentation, or forged documents. I also suspect this is going to be one that is widely used for denaturalization. Number nine, cases that are specifically referred to the Department of Justice based on pending charges. And number 10, this is a catch-all, it is any cases who are referred to the civil division that the division identifies as being in the best interest of the US to pursue denaturalization. I'm going to give you my thoughts on some of the, I think a lot of these categories, it honestly makes sense that these cases would be targets for denaturalization. Obviously, those who participated in terrorism or war crimes or serious violent or sexual offenses, who were able to obtain citizenship either through fraud or misrepresentation or just pure error from USCIS, that remedy makes sense. I think a lot of the language here as a catch-all provision for cases that the Department of Justice Civil Division thinks would be in the best interest of the US to refer for denaturalization, I think there's an element of discretion there that is a little disconcerting. I think it makes me a little uncomfortable that denaturalization as a remedy could be used based on somebody's, a bureaucratic officer's discretion. Again, there are some legal protections there, right? Just because you are referred for prosecution to the DOJ does not mean that denaturalization will actually go into effect, right? We're going to talk a little bit about that. What is the standard that a federal judge actually needs to see in order to find denaturalization? But I still think there's an element there that makes me personally uncomfortable. There is another reason that I am concerned here about the abuse of denaturalization. And I think that is the incongruence between two different types of naturalization. There are two different types of citizenship for those for naturalized citizens compared to those with birthright citizenship. I think that American law does recognize on some level that there are differences between the two. For example, you cannot run for president if you are a naturalized citizen, if you're not a natural born citizen. I think if nothing else, this shows that federal judges who hear these types of cases are going to need to exercise a great deal of judicial wisdom, let's say. They're going to need to be careful in their judgments to make sure that this sort of penalty is enforced only in qualifying cases. I think one other issue that we could talk about here is this quota problem. I think setting an arbitrary number of, let's say, 100 to 200 cases per month, if you set the incentive, you are going to get what you are incentivizing. I think if you set a monthly quota that's 10 times higher than the annualized amount of denaturalized cases that has ever occurred or that has occurred in the past 30, 40 years, you're guaranteeing that the government is going to find what they're looking for. Now, on a personal level, would I be surprised to find that there are many cases of people who have submitted fraudulent or misrepresentative documents that warrant denaturalization? No, I would not. All right, let's talk about the legal process of denaturalization. Okay, what actually needs to be proven and what are the logistical steps of this actually go into effect? So one thing to keep in mind first is that USCIS cannot revoke citizenship on its own. Neither can the Department of Justice. This does need to be formally filed in a federal court, and there needs to be a formal finding by a federal judge before denaturalization goes into effect. Let's go through a sample fact pattern for how this actually works in practice. So number one, USCIS, let's say one of these specialists from the Trump administration identifies a case for potential denaturalization. They refer this case to the Department of Justice. The Department of Justice then reviews this case and determines whether they are going to proceed with civil or criminal charges to pursue denaturalization. The government then needs to prove its case by clear and convincing evidence before a federal judge. At this point, the defendant, though, has the right to an attorney, they have the right to appeal, they have the right to the full legal process to defend themselves in court. Keep in mind here that the most important thing, the burden of proof is on the government here. As I mentioned earlier, in civil denaturalization cases, the government has to prove there's a clear and convincing standard. This is above the preponderance of the evidence standard and below the beyond a reasonable doubt standard. Okay, let's talk about the legal elements that need to be proven in order for denaturalization to occur. We're going to talk about the Massenlach decision. The precedent case regarding denaturalization that we want to talk about occurred in 2017. It's called Massenlach versus US. This is before the US Supreme Court, and it pertained to a Serbian woman who lied on her naturalization application. So some of the facts were, when she was filling out her citizenship application, she marked that she had never given false or misleading information to a US government official to obtain an immigration benefit. And the lie that she had given was that her husband did not participate in any war crimes related to the Serbian-Bosnian conflict. Essentially, what she did is she lied on her applications concerning her husband's service or involvement in the war. In the Massenlach case, because of her lie pertaining to her husband's involvement in the Serbian-Bosnian conflict, the federal court found her guilty and revoked her citizenship. But the Supreme Court, in a unanimous decision, again, every justice agreed, and Justice Ginsburg, writing the opinion, found that in order for denaturalization to go into effect, a lie or misrepresentation must be material to the naturalization itself. This means it must have actually influenced the decision to strip citizenship. The lie cannot be about something that's not outcome determinative. So in other words, the lie has to be about something that would have actually disqualified you from citizenship in the first place. It doesn't matter if you lied about your favorite color or about your friend's name of their dog. It matters if the lie, if you had told the truth, would have affected your ability to obtain citizenship. Essentially, this standard is so high. Again, the fraud or misrepresentation or the lie has to be at the heart of the matter, that unless the misrepresentation actually does apply to your citizenship itself, your eligibility for citizenship yourself, cases of denaturalization have just been really hard for the government to actually win. So what does this mean? There's a practical reality behind denaturalization cases. You got to think about the resources that both USCIS and DOJ will need to allocate to pursue these cases. This is actually a huge reason why the Trump administration's vision of mass deportations has really not gone into effect. Frankly, just to be very transparent, it's very expensive and it's time consuming to go through the litigation process to actually remove people, and in this case, to strip someone of citizenship. You got to go through the process of discovery, the process of appeals. All of these things can take a really long time to actually process. One former DHS official told Newsweek that it would be virtually impossible for DOJ to pursue these cases, or really to see the numbers that they're hoping for denaturalization. They are already stretched thin as far as resources go. So this initiative really may end up being more bark than bite at the end of the day, but we'll see in practice. All right, let's go over some practical considerations. I have never personally seen any case in my practice where a naturalized citizen was stripped of citizenship. I've never even had a single client or case that I can even think of where they were referred for stripping of citizenship. So I do think this is going to be something that we're going to see much more commonly going forward, particularly if these numbers of 2,400 a year are to actually go into effect. From a practical standpoint, what I would do if I were in this position, I would just make sure I kept great records of all of my immigration applications. So not only just your documents for your green card application or your citizenship application, I would try to keep detailed records of your temporary visa applications if you have them as well. You can think of your DS-160 applications or any other non-immigrant visa petitions you may have submitted to USCIS. The reason this matters is, one, you need to always be honest in your dealings in your life, but second, you need to be honest with your filings with USCIS or with the federal government. If they perceive that any of the information that you have submitted is misrepresentative or is inaccurate, or they believe that it's fraudulent, even if it's innocent in your case, it could lead to dire consequences, including denaturalization. In my practice, I have seen those who have submitted DS-160 applications who've put their work history at one company, saying that they worked there from one date to another, and then their resume in another application listed dates of employment differently. And I know a lot of times this is really just a matter of inconvenience or frankly laziness and not wanting to verify all of those specific dates. A lot of these forms can be difficult or annoying to complete, and so sometimes it's just easier to just put in information that you're not sure of, you're just spitballing. This would be an example of what I would specifically avoid going forward, because USCIS, Department of Justice, Department of Homeland Security can use all of these inconsistencies against you. So it's very important for you to be honest and accurate in your applications. Now, if you have been convicted of any crime either prior to or after your naturalization application, and you believe this could materially affect your eligibility to keep your citizenship, I would speak with both a criminal and an immigration attorney just to make sure that you are well informed of your options and know what to do going forward. One other point here that I really want to emphasize is if you have ever used any public benefits, whether you were qualified for those or whether you were not, I would make sure that you have kept meticulous records of that use. In the event that you are ever questioned about it, make sure you speak with an attorney. Again, I do think, if nothing else, this is going to be a very common fact pattern we're going to see, or for those who have misused government welfare or government public benefits that they were not otherwise eligible to use. So I would keep detailed records of those. Yeah, in closing here, just remember, know your rights. You are a U.S. citizen. You have the right to due process. You have constitutional protections. The government cannot simply take your citizenship away. They have to prove their case, and they have to meet one of the highest evidentiary burdens in American law in order to meet that. Now, there are approximately 26 million naturalized citizens in the U.S., and there are approximately 800,000 naturalized citizens that are added every year. Even if the government hits its most ambitious targets of 200 per month, let's say 2,400 a year, that's 2,400 out of 26 million naturalized citizens, right? That's less than 0.001% of all naturalized citizens. The concern is not about individual cases. Again, this represents such a small percentage of the electorate. I don't personally think this is going to have a significant effect on American elections. But I do think that it matters as far as reaffirming the rule of law and affirming that constitutional protections apply to each of us who are American citizens, whether by birth or by naturalization. I hope this video was helpful. If it was, feel free to hit the like or subscribe button. Feel free to leave any comments or questions. Happy to respond to those if I can. And until next time, thank you.